Okay, this is going to be part, I think, 5 of the reading of Weiss's Concise Trustee Handbook. And we're going to start with the section Express Trust versus Corporation. First, I must clarify, though I am referring primarily to corporations, included in the reference are all organizations which owe their existence to legislative acts, not limited to limited liability companies, limited partnerships, agencies, associations, etc. Though not classified as corporations, they avail themselves of benefits, privileges, and franchises of the state for their very creation and existence. Second, since we have already shown the distinct juridical personality of the trust as a legal entity, footnote 102, we will not re-examine it until we consider its personality under the Roman civil law of the 14th Amendment in a later section. But it must be noted the well-settled law that the express trust is a lawful, footnote 103, legal, valid business organization, footnote 104, with the right to hold property and sue in its business name, footnote 105. And its uses in modern business have some of their strongest roots in England, Germany, and many of the United States, where it has been recognized for its superiority and even praised by such notable authorities as the Ohio Supreme Court for its effectiveness in the business of life insurance, footnote 106. The declaration of trust has been held to be an effective substitute for incorporation, for its many advantages, which will undoubtedly shine through to the reader by the following table. I have prepared this table based upon the work by John H. Sears, who, after discussing the impact of the twin landmark cases, footnote 107, on the grave lack of profitability of using corporations for, inter alia, dealing in real estate, went to task in outlining the distinct benefits of express trusts. The works of William C. Dunn, footnote 108, Guy A. Thompson, footnote 109, and Sidney R. Wrightington, footnote 110, are cited as well. Mr. Sears says, footnote 111, and quoted from Mr. Sears, the decision of the United States Supreme Court holding that the express trusts are not subject to the federal excise tax on corporations has emphasized this method of conducting business as compared with corporations. The best legal talent was soon impressed into the service of devising a means of affording the usual advantages belonging to a corporation without the authority of any legislative act. A method placing the property into the hands of trustees who held the legal title and issued certificates, similar to shares of stock, to the Sestuike Trust, showing the interest owned by each, possessed nearly all the advantages desired. And then in brackets, there's a note, this excluded the use of limited liability companies, joint stock associations, and co-partnerships, which are organized under enabling statutes which merely enlarge the privileges possessed at common law, and they are therefore subject to state regulations which may be equally burdensome to those imposed on corporations. Italics emphasis supplied in original, bold emphasis and bracket information added. So for those of you who are watching the screen as I scroll through the book, then you will know what I mean, but the message should be complete as far as the audio as well. Okay, now there's a table here comparing the express trust on the left to the corporation on the right. The express trust is governed under equity. Trust law is the most well-settled body of law in America. On the right, the corporation, which is governed under statute, forever changing according to political agendas and schemes. On the left, express trust. Trustees are sole authority except where delegated to agents or a board of directors. On the right, corporation. Board of directors are managers with limited defined powers to conduct business, hold regular meetings, etc. On the left, third point, trustees afforded more leverage and powers are generally broader than corporate officers. Law provides that whatever an individual may lawfully do, the trust can do. The sky, or nature, is the limit. On the right, under corporation, relatively broad powers such as withholding companies, but corporation may not do whatever any individual may lawfully do. They can only do what is legal. The statute, legislature, is the limit. Point 4, on the left, express trust. Trustees' liability is limited by trust instrument and by signature on all contracts and instruments. Remember Boyd and Silverthorne, trustees not subject to subpoena. On the right, corporation, corporate officers are personally liable to legislature and to creditors for all ambiguous endorsements. Remember Enron and Global Crossing cannot escape service of process, footnote 112. Okay, we're going to look at the fifth point here for express trusts. The lifespan of 20 to 25 years at a time in order to avoid rules against perpetuities. Death of settlor or trustee has no effect on life or affairs of trust. Succession of power is quiet and private. On the right, with the corporation, lifespan is perpetual or a certain number of years according to legislative requirements. All officer changes must be reported, which records are open for public review. On the left, under express trust, point 6, trust is not required to obtain business license, footnote 113. On the right, for corporations, the opposite is the case. Point 7, trustees are not required to file reports with any entity and are accountable only to the beneficiary, governed strictly under principles of equity. On the right, required to file statements and reports quarterly, etc. On the left, business name for express trust, business name is naturally protected by injunction. May also use trade name or trademark for trust purposes without registration. Footnote 114. On the right, under corporations, must apply for and secure fictitious firm name and must register all trade names and trademarks. On the left, under express trusts, all federal excise tax and state organization and franchise taxes are legally avoided. On the right, under corporations, the opposite is the case, except for state taxes in certain states. In either respect, all corporations are taxed indirectly via inflation. Footnote 115. For express trusts, they are not subject to foreign corporation laws of any state, not inherently subject to commercial regulation, except for income, quote-unquote income, derived from corporate stock and physical franchises under Article 1, subsection 8, clause 1 and 3. Express trust is a valid legal entity in all states of the Union. Footnote 116. On the right, for corporations, they are inherently subject to all foreign corporation laws and public policy regulation. On the left, express trusts, the trust may function as an Article 4, subsection 2, citizen of the United States via its trustee, not a 14th Amendment citizen, footnote 117. This citizen is understood in constitutional law as the private citizen. And on the right-hand side for corporations, corporation is 14th Amendment citizen, footnote 119, regardless of citizenship of corporate officer. Generally, state corporations require officers to be citizens as well. The citizen is inherently public due to the nature of the amendment, footnote 120. Continuing on, Express trusts. Trustees have absolute rights and privileges to engage in commerce under protection of the federal Constitution, footnote 121. On the right, corporate officers have relative right and privileges to do so and incur more taxability by doing so. Engaging in commerce, that is. On the left-hand side, we have trustees issue certificates in the manner prescribed by trust instrument. Certificate holders have no say in the administration of trust affairs. On the right-hand side, we have corporations must go public, quote unquote public, in order to issue stock. Stockholders have a relative say in affairs depending on the extent of their holdings. On the left-hand side, under express trust, interests of the beneficiary well protected by equity, power to secure information as to the action of the trustees and trust affairs is, no doubt, superior to the rights and remedies of stockholders in corporation. On the right, under corporation, stockholders' rights protected by courts, yet the basic statutory nature of corporations allows for abuse. Stockholders are generally at the mercy of someone. On the left, we have, or express trust, units of interest in the trust are not personal property of certificate holder and carry no liability as such. On the right, under corporations, shares of stocks are personal property in hands of owner, and taxes issue on same property against both owner and corporation. On the left, under express trust, no legal obligation to maintain the capital and refrain from paying dividends out of capital. The trust instrument governs. On the right, with corporations, the exact opposite is the case. And finally, under express trust, they may prosecute, defend litigation in trust or trustee name without compromising legality. Same rules as to parties and procedure at law and in equity are applicable. And on the right-hand side, under corporations, may bring and defend litigation in the corporate name and entity only. The process of piercing corporate veil succeeds mostly due to confusion of personal and official capacities by officers. While the mortality rate of corporations and the like have historically remained high, express trusts remained, and indeed to this day continue to remain vital. Footnote 122. Also, as the table shows, many of the powers of an express trust are substantially the same as those of a corporation in effect, but without the legislative requirement of registration in order for those powers to be activated. These advantages and more have been and are still seized by some of the shrewdest, wealthiest individuals and families in America and from abroad. But the widely perceived yet untraceable wealth of such individuals and families like the Rothschilds, Rockefellers, Kennedys, Forbes, and many of the American founding fathers, plus countless modern-day politicians, are strong circumstantial evidence of this. One may find many articles and information, as well as quotes, footnote 123, attesting to this. Lastly, it should be mentioned that, unlike the corporation, there is no lawful method by which to pierce the trust without the express permission or implied consent of the trustee, or some unlawful activity on the part of the trust giving rise to a bona fide cause of action. As a result, virtually no direct evidence of the trust's existence can be found unless it is made to be found via recording. Even then, it can only be heard by a court of competent jurisdiction, which, as you shall see in the sections ahead, is very hard to find nowadays. This is protection at its finest, hiding in plain sight, for as the maxim goes, bene vixit, qui bene latuit. And that's footnote 124, which I'm going to have to look up. And it's translated to mean, he lives well who conceals himself and his assets well. And that's from Ovid, circa 43 BC to AD 18. Understanding commerce. Here's where we begin to address the express trust in action. As shown above, the trust may engage in all manner of trade and commerce, footnote 125, but before taking the step of doing so, the reader would greatly benefit the trust by understanding the nature of commerce in 21st century America. And for my brief explanation of the subtle intricacies involved, I will rely upon the two works by Lee Brobst et al., footnote 126. I will not go into a detailed explanation of the Constitution or the history of commerce for want of space, but I would suggest that the reader read the works relied upon herein. When the trustee is engaging in trade or commerce in behalf of the trust, acting under general common law, the trust is within the jurisdiction over which the literal and absolute protections of the Bill of Rights extend, and he has no direct contact with the federal government. Under right of contract law protected by the federal Constitution, the trustee may enter into the 14th Amendment jurisdiction via contract, i.e., by willfully availing the trust of benefits like the quasi-corporate privilege franchise of limited liability for the discharge of debts using Federal Reserve notes pursuant to the economic system established under former H.J. Res. House Joint Resolution 192, footnote 127. Contrast discharge with the payment of debts with standard gold-backed currency under the original Coinage Act of 1792. Under this jurisdiction, the federal government, Congress, has full and direct contact with the trust as they, quote, as they see fit for the benefit of public policy regulations known as codes and statutes of this jurisdiction, end quote, footnote 128. This makes the federal government a third-party intervener in the affairs of the trust by operation of law, footnote 129, because the trust, as with the 14th Amendment citizens, is being allowed to get away with not truly fulfilling its commercial contracts as is required under the common law of contracts. I will show how this can be avoided in a later section, in parentheses. The resulting nexus or confederacy developed under HJR 192 or House Joint Resolution 192 is an affiliation known better as an association, footnote 130 in brackets. Quote, and the common enterprise of this unincorporated society as to offer all Americans a so-called privilege in the form of what is better known as a, in brackets and quotes, quasi-contract to participate in commerce without payment of debts for social security purposes. Moreover, this unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1, Section 10, but it is allowed, upheld, and protected by Article 1, Section 10 that upholds the obligation of contracts. Footnote 131. This amounts to a, quote, federated unincorporated society by operation of law, which is contractually protected by the Constitution in the same way the express trust and its trustees are, end quote. And the trust and or trustee reserves the right to, quote, domicile themselves in the Union under Article 4, Section 3, Clause 1, and thus to contract under Article 1, Section 10, despite the fact that they cannot pay their debts. In other words, Congress cannot compel the trust or its trustees to participate in a federal interstate unincorporated banking association under Article 4, Section 3, Clause 2 in House Joint Resolution 192 for the non-payment of debts. The choice of law is up to each person still. Footnote 132. Corporations are artificial creations of the state or federal government under physical charter, franchise, issued via state or federal civil law for commercial regulation under Article 1, Section 8, Clauses 1 and 3. They are not under the literal common law because of the charter, parentheses, franchise. Any legal action against the corporation is legally called in rem action, which is in quotes, in rem, because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. Footnote 133. Under the letter of the constitutional law, there is no commercial regulation, but HJR 192, in brackets, along with 15 USC, brought in a third party for commercial regulation for the Social Security public policy. Remember, equity compels performance. The law views unincorporated associations as a danger to the substance of the common law because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth, thus the reason for all the federal and state regulatory agencies. In other words, there is a presumption by implication in the civil law that a charter, in parentheses, a metaphysical, abstract, unreal type, end parentheses, exists because persons are availing themselves, parentheses, volunteering, of the privileges pertaining to HJR 192. Therefore, these persons come under a quasi-in rem jurisdiction of the civil law in order to regulate, control, parentheses, including compel, those that are outside the literal common law principles. Footnote 134. The many participants under this system, especially the 14th Amendment citizens from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4, Subsection 3, Clause 2, and reinforced by the landmark Erie Railroad Company versus Tompkins, footnote 135, decision. This is the basis for the federal and state government's compulsion of persons to its private international law, i.e. the spirit, not the letter, of the common law mixed with public Roman civil law under Law of Nations per Article 1, Subsection 8, Clause 3 and 10, and Article 6, Clause 2, nowadays commonly known as codes and statutes, parentheses, state or federal, to regulate everything as a matter of commerce. Footnote 136. Without getting into the history of religion and speaking purely from an analytical perspective, the Roman civil law, as a base model for commerce regulation, was developed out of necessity of the church to avoid political scrutiny for its handling of ever-increasing amounts of precious metals. It had become a, quote, storehouse for the money and property the people were persuaded to give in exchange for limited liability, go directly to heaven instead of hell. As the people became more educated and saw what was really behind the power of religion, brackets in generating wealth, the Roman Church fell under greater and greater criticism. This led to the development of a banking system to handle and control church wealth and take the critical focus, brackets, away from the church. Footnote 137. Quote, the bank learned from the church about limited liability. If you could get people to borrow money beyond their ability to pay back, you could get them to keep performing, brackets, paying interest in one form or another on a debt, liability, without ever demanding it, the principal, back, thereby loaning out the same credit to more than one individual or company. This meant that the bank was limiting the liability of the borrower, so he was not fully responsible for the debt as long as he continued to perform to paying the interest. This way, real money, gold, became credit, paper money, by loaning to more than one person. Being involved in this sort of commerce was called private commerce. With the church's control over wealth, this private commerce became standard practice in world trade upon the sea. Private international or admiralty marine law became known as Roman civil law as it began to figure heavily in the politics of every city and county it touched through international commerce. Footnote 138. By operation of this body of law, particularly its in rem element, all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state, discussed earlier, see footnote 24. These objects, like vessels in traditional admiralty practice, are vested with a distinct quasi-corporate juridical personality, but unlike vessels, are capable of suing and being sued in personam. Footnote 139. 14th Amendment citizens of the United States, whether state or federal, chartered corporations, or metaphysical chartered corporate colored public persons, therefore, are akin to public vessels of the United States within the broad meaning of the Public Vessels Act and are regulated accordingly. The United States, as with the Roman Church, is considered in international law as a ship of state, quote, unquote. The express trust, then, is akin to a private vessel of the United States of America, lowercase u, lowercase s, of America, navigating through the often hostile water called interstate commerce, which is international commerce, via the United States treaties. Doing business. Even though the express trust is technically not a business trust, in quotes, footnote 140, within the established meaning of the term, this in no way prevents or inhibits the trust from engaging in all manner of business the trustee is permitted to under declaration, and it need only obtain the franchise of a business license if it anticipates doing express business in the above described jurisdiction. Footnote 141. The trust may operate a business, acquire a business, sell or otherwise dispose of its business, or even contract under the limited liability system and become a taxable entity. The choice is yours. The only thing which may bar the trust from conducting a particular kind of business in any certain jurisdiction is the public policy of that jurisdiction, regarding which, it has been admitted, most states have not passed upon the subject directly. Footnote 142. Regardless of the nature of the business, there is a due notice rule which confers a duty upon the trustee under equity. The rule consists of two parts. The first is that he should sufficiently distinguish and represent the nature of the trust to the party with whom he is doing business. It is of the utmost importance in the forming of business contracts that full disclosure be made on all letterheads, business cards, checks, bills, and order blanks, papers, etc., so as to prevent any claims of lack of disclosure from arising in the future. But prudence dictates also that a trustee must not disclose every fact regarding the trust, its declaration, and its affairs. The first part of the due notice requirement can be sufficiently accomplished simply by employing the designations irrevocable express trust organization, express trust organization, quote, trust organization, end quote, or organized under declaration of trust, beneath or next to the trust name. It must not be excessively revealing about the trust. The trustee has a duty to protect the privacy of the trust, but it also must not be misleading. The trustee has a duty to not compromise the integrity of the trust. He is in no way prohibited from exercising the utmost shrewdness. Footnote 143. The second part is that he should stipulate in plain and certain language in all written contracts and obligations that the trust is only liable for its obligations and that neither the trustee nor interest holders are to be held to any personal liability in the contract. Footnote 144. You may also wish to cite the provision of the trust which so limits his and or the interest holder's liability, but this is often unnecessary. And the trustee should always designate his title either under or immediately next to his name and signature. Footnote 145. The trustee should obtain a mailing address for the trust, and though he is the principal and holder of the trust property, it is generally prudent to refrain from mixing the trust affairs with his own. He should also obtain all separate business necessities, telephone service, utilities, etc., for the trust. Logic follows that he should do these things regardless of whether he is operating trust business or not. He should, for all intents and purposes, maintain a strict separation of the trust's identity from his own. Limiting liability and risk. In all contracts, as we have already noted, though it is best to always apply it, the trustee's mere designation of title is not sufficient to limit his liability or remove the risks to his own individual assets. Instead, he must employ the proper language either within the terms of the contract or above or beneath his signature or in any proper place where it will appear unambiguously, indicating something to the effect of, quote, the property and funds of the trust organization only are liable for contract obligations. Individual trustees or interest holders are not personally liable. That's bullet point 1. Bullet point 2, quote, John W. Doe, acting as trustee under the Declaration of Trust dated October 1st, 2005, establishing the trust organization therein called ABC Trust and not individually. Bullet point 3, John Doe as a trustee and not personally. 4, in quotes, as trustee but not personally, or last one, without recourse to trustee. Any form of words that will convey in certain unmistakable language to the other party that he is dealing with an express trust is sufficient notice under the rule. Whether it is necessary to also cite the provision of the trust instrument which limits his liability is a decision left to the discretion of the trustee. To quote Mr. Justice Woods in the case of Taylor versus Mayo, footnote 146, quote, if a trustee contracting for the benefit of a trust wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally responsible, but that the other party is to look solely to the trust estate, end quote. And in the case of Shoe and Leather National Bank versus Dix, footnote 147, the court held with regard to the promissory note made by the trustees under such limited liability that it was not within the power of the court to change the trust's liability on the note into a personal one of the trustees. That liability on a contract must be determined by the terms of the contract itself, and that a contract entered into under such limited liability, be it a note, agreement, etc., cannot be converted into one under personal liability by law. To do so would be to alter the terms of the contract itself. Furthermore, any such stipulation is ultimately subject to the acceptance of the other party in order to gain validity in the contract.